ಚೆನ್ನಾಗಾಯ್ತಲ್ಲ, ಅದನ್ನ ನೀವು ಹೇಳಿದ್ರೆ ನಿಮ್ಮ ಮಾತು ಮುಗಿನ ನಂಬೋರು ಯಾರು?
Your Lordship, Exhibit D3 has been marked, Your Lordship. It's a...
Marking is not evidence, amma. What are you up to? I can also mark that I have given the money to you. Do you agree? Do you agree? Judge is saying no. And I am writing a letter. I have given the money to you and mark it in evidence.
Your
Do you
Lordship,
agree?
that agreement is signed.
Do you agree is the question.
No.
No is the answer. You know it very well. Therefore, you can, what happens to you should happen to others also. Anything else?
Your Lordship,
Anything
even
else?
The bank statements have been marked as Exhibit P10.
ನೋಡಿ 118 139 ಎರಡು ಇದು ಪ್ರಿಸಂಪ್ಷನ್ಸ್ ಇದೆ, ಗೊತ್ತಾಯ್ತಲ್ಲ. ಈ ಈ ಈ ಪ್ರಕರಣಗಳೆಲ್ಲ ಇಷ್ಟ ತನಕ ಎಳೆಯುವಂಥದ್ದು ಇರಬಾರ್ದು ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟಿನ ಅಭಿಪ್ರಾಯ ಇಂಡಿಯನ್ ಬ್ಯಾಂಕ್ ಅಸೋಸಿಯೇಷನ್ ಕೇಸಲ್ಲಿ, ಗೊತ್ತಾಯ್ತಲ್ಲ. ಇವೆಲ್ಲ 6 ತಿಂಗಳಲ್ಲಿ ಮುಗಿಬೇಕು ಅಂತ. ಇದು ಸಿವಿಲ್ ಕೋರ್ಟ್ಗೆ ಹೋದ್ರೆ ಬಹಳ ಲೇಟ್ ಆಗುತ್ತೆ, ಜನಗಳಿಗೆ ಕ್ರಿಮಿನಲ್ ಕೇಸು ಅಂತಂದ್ರೆ ಭಯ ಬರುತ್ತೆ, ಆಗ ಬೇಗ ದುಡ್ಡು ಕೊಡ್ತಾರೆ ಅಂತ ಎನಾಕ್ಟ್ ಮಾಡಿದ್ದು. ಈಗ ನೋಡಿದ್ರೆ ಇದು ಸೆಷನ್ಸ್ ಕೇಸೇ ಬೇಗ ಮುಗಿಯುತ್ತೆ, 138 ಮುಗಿಯಲ್ಲ. ವಿ ಆರ್ ಇನ್ ದಟ್ ಸ್ಟೇಜ್ ನೌ. Total pendency of the criminal cases across the country as per the NCRB data, 138 Negotiable Instrument Act is contributing 1/3. 100 ಕೇಸ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದ್ರೆ 33-35 ಕೇಸು 138 ಒಂದಿದ್ದಾವೆ. ಜನ ನಗ್ತಾರೆ. ಚೆಕ್ ಡಿಸಾನರ್ಗೆ 10 ವರ್ಷ ಕೇಸ್ ನಡೆಯುತ್ತಾ ಅಂತ ಕೇಳ್ತಾರೆ. ಮಿಡ್ಲ್ ಈಸ್ಟ್ ಕಂಟ್ರೀಸ್ ಇದೆಯಲ್ಲ, ಅಲ್ಲೇನಾದ್ರು ಆಯ್ತು ಅಂತಂದ್ರೆ ಕೇಳ್ತಾರೆ, ದುಡ್ಡು ಕೊಡ್ತೀಯಾ ಅಂತ. ಹ್ಞೂ ಅಂತ ನಾನು ಕೊಟ್ಬಿಡ್ಬೇಕು, ಇಲ್ದಾರೆ ಯಾವ ಕೈಯಲ್ಲಿ ಸೈನ್ ಮಾಡಿದಿ ಅಂತ ಕೇಳ್ತಾರೆ. ಶುಕ್ರವಾರ ನಮಾಜ್ ಮಾಡಿದ್ಮೇಲೆ ಆ ಕೈ ಹಿಡಿಸ್ಬಿಟ್ಟು ಕದರ್ಸ್ಬಿಡ್ತಾರೆ, ಮುಗ್ದೋಯ್ತು. ಇನ್ನು ಜನ್ಮೇಪಿ ಒಂದು ಸೈನ್ ಮಾಡೋಂಗೇ ಇಲ್ಲ. ಇಲ್ಲಿ ಥರ ಏನೋ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ 8 ವರ್ಷ, ಅಪೀಲ್ ಕೋರ್ಟ್ನಲ್ಲಿ 4 ವರ್ಷ, ರಿವಿಷನ್ ಕೋರ್ಟಲ್ಲಿ 3 ವರ್ಷ ಆದರೂ ಅಡ್ಮಿಷನ್ ಆಗಲ್ಲ. What are we trying to do? What are we trying to tell the society? ನಿಮಗೆ ಬರಬೇಕಾದ್ರೆ ದುಡ್ಡು ಹಿಂಗೆಲ್ಲ ಒಪ್ಕೋತೀರಾ ನೀವು? ಇಲ್ಲ ಅಲ್ಲ. 65,000 ರೂಪಾಯಿ ಮೇಂಟೆನೆನ್ಸ್ ಹಣ ಕೊಡಲಿಲ್ಲ ಅಂತ ಅವ್ನು ಹೆಂಡ್ತಿನ ಮರ್ಡರ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾನೆ. ಅಂಥದ್ರ ಲಕ್ಷಾಂತರ ರೂಪಾಯಿಗೆ ಅವ್ನು ಸುಮ್ಮನಿದ್ದಾನಲ್ಲ, ಇನ್ನೇನು ಮಾಡ್ತಾನೆ ಪಾಪ. If it is a case of misuse, you should have taken action. You have not taken any action. Barkoli, what's your good name?
Tejaswini, Your Lordship.
They heard Tejaswini for Shankarappa and Shri Raju for Prakasha. Revision petition is by the accused who suffered an order of conviction in CC number 9671 of 2015 for the offence punishable under section 138 of the Negotiable Instrument Act and ordered to pay a fine of rupees 18 lakhs, out of which rupees 17 lakhs 90,000. 18 lakhs 10,000, of which 18 lakhs to be paid as compensation and rupees 10,000 towards the differing expenses of the state. And accused was also ordered to undergo simple imprisonment for a period of 9 months in default of payment of the fine amount, which was confirmed in criminal appeal number 1151 of 2018. First, next para. Facts in brief which are utmost necessary for disposal of the petition or ascender. A complaint came to be lodged by the complainant under section 200 CRPC alleging the commission of the offence under section 138 of the Negotiable Instrument Act by contending that in October 2007, accused approached the complainant seeking hand loan of rupees 10 lakhs with a promise to repay the same, and the same was not repaid despite repeated demands. First, ultimately on 29/1/2008, accused passed on a check in a sum of rupees 10 lakhs drawn on Syndicate Bank, Wilson Garden, Bangalore. First, set check on presentation returned with an endorsement referred to drawer on 18/2/2008. First, legal notice came to be issued, which was replied with an untenable reply by the accused, and therefore complainant sought for action. Next para. Presence of the accused was secured, plea was recorded. Accused pleaded not guilty, therefore trial was held. In order to prove the case of the complainant got examined himself and one witness by name Narayan Reddy, full stop, as PW2, full stop. On behalf of complainant, 10 documentary evidence were also placed on record, which are exhibited and marked as Exhibit P1 to P10, comprising of dishonored check, bank endorsement, copy of the legal notice, postal acknowledgement, reply notice, deed of sale, bank statement. First, next para. As against the evidence placed on record by the complainant, accused got examined himself as first defendant, DW1 and one Sanjay as the DW2. First, 3 documents were placed on record, which are the photocopies of the agreement, copy of the check and lease agreement as exhibit D1 to D3. Next para. Accused statement as contemplated under section 313 CRPC was also recorded, wherein accused has denied all the incriminatory circumstances. Next para. Thereafter, the Larret trial magistrate heard the parties and by considering the oral and documentary evidence placed on record, convicted the accused and sentenced him as referred to supra. Next para. Being aggrieved by the said judgment, accused preferred an appeal before the district court in criminal appeal number 1151 of 2018. Next para. Learned judge in the first appellate court, on reappreciating the material evidence on record in the light of the appeal grounds, reappreciated the evidence and dismissed the appeal by considered judgment dated 5th February 2020. First, thereafter accused is before this court in this revision. Next para. Ms. Tejaswini, Land Counsel representing Sri Shankarappa, reiterating the grounds urged in the revision petition, vehemently contended that both the courts have failed to appreciate the material evidence on record about the misuse of the check that has been satisfactorily established by the accused by examining himself as well as one witness. First, she also pointed out that actually the check was issued in favor of one Ashok Kumar, and Ashok Kumar in turn has handed over the check in favor of the complainant, which has been misused by her, and there is no privy between the accused and the complainant, which has been lost sight of by both the courts and sought for allowing the revision petition. First, per contra, Sri Raju, Land Counsel representing the counsel for complainant, supports the impugn judgments. Next, para, having heard the parties, this court perused the material on record meticulously. On such perusal of the material on record, the check in question is signed by the accused is not in dispute. First, according to the accused, the check has been handed over to Ashok Kumar. First, to substantiate the same, no material is placed on record, nor Ashok Kumar has been examined. First, Xerox copy of the lease agreement marked at exhibit D3 is the document for which has been relied upon to show that check is in fact handed over to Ashok Kumar. First, assuming that the check has been misused by the complainant as is propounded by the accused, as a normal prudent person, accused would have taken some positive action against the alleged misuse by the complainant. First, no such positive action has been taken by the accused in this matter, nor Ashok Kumar has been cited as the witness. First, at least witness summons should have been taken as against the Ashok Kumar to show bona fides that actually the check has been issued in favor of Ashok Kumar and it has been misused by the complainant. First, in the absence of any such material evidence placed on record, theory of misuse of the check loses its significance. Next para. Having said this, the learned trial magistrate considered the material evidence on record, especially exhibit P9 and P10, and has drawn the presumption available to the complainant under section 139 of the Negotiable Instrument Act in accepting the case of the complainant. First, next para. No doubt the presumption available to the complainant under section 139 of the Negotiable Instrument Act is a rebuttable presumption. In the case on hand, the rebuttal evidence that is placed on record is the misuse of the check which has been discussed by this court, supra, and the same has not been probabilized. Under such circumstances, there is no rebuttal evidence placed on record. Resultantly, the conviction order passed by both the courts needs no interference in this revision. Next para. Having said this, the Larret trial magistrate has imposed 10,000 rupees as the fine amount towards the state, towards the defraying expenses of the state. First, since the list is privy to the parties and no state machinery is involved, the sum of rupees 10,000 fine imposed for defraying expenses of the state cannot be countenanced in law and same needs interference in this revision. Accordingly, following order. Revision petition allowed in part while maintaining the conviction of the accused for the offence punishable under section 138 of the Negotiable Instrument Act. Fine amount is reduced from 18 lakh 10,000 to 18 lakhs with default class as is imposed by the learned trial magistrate. Sum of rupees 10,000 ordered towards the defraying expense of the state is set aside. Rest of the sentence stands unaltered.